Hello, and thank you for joining our third annual Day with DISA. Before the session gets started, let's go over a few things. A copy of the presentation will be available to download once the session has ended under the Materials section. If you have questions about the information in this session, enter them in the Q&A section below, and the speaker will answer them once the session has ended. If we don't get to your question, we'll reach out to you at the end of the conference. If you have questions about the topics or trends that are mentioned throughout Day with DISA and how they pertain to your company, and you'd like to reach out to one of our team members directly, hit the chat icon at the bottom of daywithdisa.com and you'll be connected directly with one of our team members. Thank you for attending live. Each of our live attendees is eligible for our prize drawing at the end of the conference. And each session that you attend live increases your chances of winning either a Nintendo bundle or a brand new iPhone 12. Finally, I'd like to take this time to thank all of our sponsors for their participation in Day with DISA. Specifically, I'd like to call out CRL, our title sponsor for 3 years running. We'd like to thank our platinum sponsors, OraSure, Quest Diagnostics, Samba Safety, and Psychomedics. All of our sponsors' support is greatly appreciated. With that, let's get started. Enjoy your session.
Hello, and thank you for joining us for our very first session of Day with DISA. Today we've got two very experienced guests, and honestly, I can't think of any better way to kick off Day with DISA. We're joined by Bill Current, president of the Current Consulting Group. Bill brings more than 30 years experience in the industry. He's one of the go-to experts for all things drug testing policy related. Bill, how are you doing today?
Doing great. Thank you, Thomas.
We're also excited to have Dr. David Kuntz. He's the Executive Director of Analytical Toxicology for CRL, Clinical Reference Laboratory. Dr. Kuntz also has more than 30 years experience, and he's currently a leader in CBD oil research for the federal government. David, how are you doing?
Doing excellent. Thank you.
Let's go ahead and dive straight into this, but before we do, I just want a little bit of housekeeping. If you have a question throughout the session, go ahead and drop it in that Q&A section at the bottom right. We'll answer as many questions as we can at the end of the presentation. If we're unable to answer your specific question, we'll reach out after the conference and touch base with you directly. Additionally, if you'd like a copy of this presentation, we'll make that available under the materials section at the end of the presentation. So as we're getting into Q&A, the presentation will be available to download there under the PDF section. Without further ado, I'll hand it over to you.
Well, let me talk to you for a few minutes today. We're going to get into CBD oil. Certainly CBD has been a hot spot for drug testing for the last couple of years, especially since the Hemp Farm Bill. We'll go over a brief review of CBD. It is, we mentioned earlier, I've been involved in the testing with CBD in humans and with the federal government, so I have a great deal of knowledge on this, and we'll share as much as we can quickly for you. Just as a very short background, CBD, is one of those compounds in marijuana. It was discovered or identified in around 1940, and CBD behaves much in the same way as marijuana because they come from the same plant, and their actions are really focused on two different receptors. They're commonly called CBD1, which is in your central nervous system, and CBD2, which is outside. Well, obviously, for much of this, we're looking for THC in marijuana. You really are focusing on CB1 receptors to get those effects. Well, CBD2 does different things, and the actions are actually very, very complex. It involves a lot of different neurotransmitter systems, and it's still being discovered how it's interacting with each of those components within your body. Now, CBD is metabolized by the liver, much like marijuana is, and I'm going to torture you a little bit later with a couple kind of like chemistry slides, but it's chemistry light, so you won't fall asleep. But it will demonstrate how it comes from one product breaks into two, and what leads to all of this discussion of purity and contamination. We'll get into that. So we do know it wasn't until we started having the epilepsy research with some of these refractive children with seizures that CBD was really a good drug. I mean, things that control the seizures was started with CBD and became a springboard for many things else. Because CBD was always at a very low percentage. You know, it was 1% of THC in the plant, 2%, and it was kind of the you know, where THC kind of made you excited, and this did the opposite. It's the yin and yang. It kind of held you down a little bit from preventing from having too much effect from all of this. So it is a kind of a CNS depressant, which made the seizures disorders improve. Now, CBD really wasn't much of an issue until the hemp bill of 2018. There was an earlier hemp bill, but this is the one that really springboarded all of this. And I think probably almost everyone in the audience has heard that, you know, it is a hemp if it's less than or equal to 0.3% THC by dry weight. So that is the line determines whether it falls in the marijuana line or in the hemp line. But what I think people fail to realize, it is a farm bill. So a lot of this is being controlled by the USDA, Department of Agriculture. And this is where they're providing all of the procedures, the bookkeeping, the inspections, you know, how do you dispose of it? You know, if your plant has too much THC, it falls in the marijuana realm and you have to destroy your whole crop. So this is all very important material. But another part of this was that instead of this being a state issue only, like Kentucky, I believe, was the state that really promoted this, you now have it treated much like any other product, so you can move it from state to state. So it becomes another crop, another food, if you will, and not a drug. Now, we all know that it's been talked about that we have the issues with purity of the CBD oil. And there was on August 21st of this year, the DEA proposed new standardization rules to try and clean up this product. Now, they're proposed, so the products are still a little bit sketchy. You know, you'll have some good, some bad, some that claim to be what it is, some will have additional drugs, and I'll conclude with that at the end of my portion before we get into Bill's commentary on marijuana laws. Now, the CBD, you know, there's a lot of comments out there about CBD, how big the market is. I think I've seen one that was $20 billion a year this week. But this came out of the Consumer Reports, and you know what, they're not known for their research on product use, but more on kind of a neutral party for evaluating electronics, appliances, and all of that. So I kind of trust what they've done a little bit more. It's not pro or anti-industry, kind of taking the middle road. But what we see here is that 26% of the Americans have tried CBD in the last couple of years. Pretty high percentage. I think everyone is looking for a product that's non-legal, that's non-addicting, non-opioid, because you know we're just still recovering from the opioid addiction. Something they can use. So they broke it down a little bit further. Who's using CBD? Obviously, you know, the highest percentage, 40% of the 18 to 29-year-olds are using it, you know, all the way down to the 60-plus group, which I unfortunately qualify for. You know, that's 15%. And these two groups are going to be using CBD for different purposes. Continue. Now, what do they use it for? So they're on the bar graph, you know, we have a couple categories or 4 categories, you know, to help you relax, anxiety, That's 37%. Now the people that get into the 63%, 63% said it was very effective. So it helps people relax. 16% was not effective or minor. 24% claimed it helped with joint pain. I certainly have had friends and acquaintances that are using CBD on their hands, their joints, for arthritis, and they claim in many cases that they are seeing relief. So 38% say they're effective, 20%, 7% not so effective. For fun and recreation, well, that probably falls in the younger category, but some 25% or 24%, and the same with non-effective. There is a little bit of this to just let's go see how it works. And of course, sleep was 10% of that market, why they use it. 52% said it's effective. Uh, you know, all of these things are important. I was reading today, uh, maybe it was yesterday, about CBD, and now, there's this long list. It pretty much cures or helps in every issue. But now they're saying it's better than mouthwash because it controls bacteria in your mouth. So if you have your CBD toothpaste, it's going to help prevent cavities. And I don't know if any of that is true, but it seems like it's encroaching in every product that we have. So millennials appear to have more stress issues. No doubt. I mean, they got their school loans, they're trying to raise a family. Whereas when we get into the baby boomers, obviously we were the ones with the joint pain, the bad knees, and vast majority are used by that group. So it's really not anything too revealing, but they are used for different purposes based on age groups. Now, we got to have a picture. You just can't live off a chart. So do the little blow up of marijuana, of these little buds. And, for most people, these are trichomes. So it's those on the right side of your page. You got kind of like the little stem with the bulb. This is all very important. That leads into the next discussion I'm going to have in the next slide. But this is where THC is being produced and CBD. That all happens right within these microscopic little trichomes, and they're prevalent on the flowering bud. There's the more sunlight a plant gets, the more ultraviolet light, the higher the percentages of THC that it will produce. That's why you like to space them around a little bit, so that as even from the top to the bottom of the plant, you have more THC at the top because it gets more sunlight. So the bottom of the plant gets less and less. So it's all part of that farming operation, if you will. And then on the left-hand side, you see the little specks. That's what each one of those little trichomes are. Within that little trichome that we just saw, this chemistry reaction's going on. So when you look at a CBD bottle, there's going to be abbreviations for contents. And what you see on there, it depends on which container you look at, you're going to see CBGA. That is the starting point of this chemistry. And then you have a THCA or synthase and a CBDA synthase. Those are enzymes. So they're both present. And depending on CBDG, which one gets acted on, you're either going to produce the CBD line or you're going to produce the THC line. So within that bottle, you kind of remember back in the days, you'd say you always have to heat marijuana, that you have to heat the brownies in the oven at 350 degrees and to convert inactive THC to active THC. And that's what is going on by light exposure, what the heating to activate that molecule. So as a toxicologist, I'm looking at THCA, and on the bottom of your federal drug report, it lists THCA as the metabolite, but it means something different to me as a toxicologist versus growers. And the same thing goes for CBD. There's CBDA, we produce that in urine. It's also the starting point or one of the compounds in the plant. So unfortunately, we all kind of use the same jargon for abbreviations, but I can assure you that THCA in your bottle of CBD that you're going to see is not the same product that you're going to see in the urine. Now, this is actual data from a urine from one of the human subjects in a study. This stuff was done, and it's published type of data that we get with the National Laboratory Certification Program at Johns Hopkins University in SAMHSA. So just to point out how important these are, you know, when we smoke marijuana, not we, someone, levels in the urine from a single marijuana joint will probably hit 50 nanograms per mil, 50 nan, which isn't too much. Now, when I take CBD, I'm taking much more. And this is from a single dose from one of those subjects. So we talked about CBDA. Well, let's focus on the green line in the middle. CBD, I get levels like 400, 500 to 1,000, depending on if it's too often. CBDA, much lower, but the 7-hydroxy is the highest one. So we get like 1,400, whereas in urine, I'd see, if I was looking at marijuana, like 50. So the liver works on this very, very well and to convert this. And when we go looking, we're involved in, we looked at 6,000 samples from regulated and non-regulated industries, and we confirmed each one to look for these products. Now, for vast majority of these, you know, we saw no marijuana, no CBD. The prevalence of use seems to be claimed to be far greater than actual. But there were a couple that we did see high hydroxy CBD in them, but very few. Out of the 4,000 non-regulated, you know, there's 3 or 4, you know, out of 4,000 samples. And remember that the CBD does not trigger positive drug screens when there's only CBD taken. It just doesn't. We did all of that work in urine. CBD does not trigger a marijuana positive, only THC does. So we have these different types of things and different ratios, and most of this kind of peaks around the 4 to 5 hours. I think I have one more slide kind of dealing with this. So we have this conversion, kind of talked about that. There's been concern that the stomach's going to convert it. Well, in a laboratory, I can make that happen to a small extent, but in vitro, that means out in a test tube, I can do that. But when we did all the work with the urine, we didn't see this occurring in humans. So the stomach acids, you know, you have food in your stomach, it's not as acidic as strong acid because you're taking with food, it's elevated. It seems to be absorbed without this conversion. Now, there's also been discussion about confirmation methods creating this. And that's been debunked as well. The National Laboratory Certification Program put out proficiency testing from 0 to 1,000 nanograms or whatever it was in the urine, and everybody passes. So even though it is theoretically possible, if you send your samples to a federally certified lab, you're not going to have this conversion and, you know, potential litigation. The laboratories have this data in their pocket to go to court with. Now, there's also been a little bit of interest. You know, it's kind of like prescription meds. You know, everybody's got like an oxycodone or hydrocodone in their closet or their bathroom drawer for a tooth problem. But it, again, if you have really old CBD, it appears that it will convert, just like what sitting in the sunlight. Old THC in a field will convert to active with the UV light. So if you have older products, you know, old products, I mean, like a year, not 30 days, it'd probably be best as a consumer to get rid of those. There's also been studies done with CBDs at urine pHs. Nothing is converting. So it doesn't matter if your sample's been positive for marijuana, you're going to do this litigation case, and you know, more THC is going to appear or not. This is stable. If anything, it degrades into something else, and it's no longer a concern. One more, I think, is what I have. So we have all these, giving you a little bit of an overview, but there's been the study that was done in this last year from the University of Mississippi. They evaluated 25 urine products, or excuse me, CBD products, and you know, kind of broke them out here for you. 3 products kind of made labeling claims. They're within 20%, you know, typically whether it's about 10 milligrams, you know, so between 8 and 12, if you will. 15 were well below, so you paid your $30 or $50 and didn't really get a quality product. And then 3 of them had none. So that's not too surprising. You know, 2 had more than 50%. So I'll let you read through that. But the one product which was quite alarming that they reported, one, it was 45% THC. So be very, very careful in what you buy. Only go through the best qualified vendor that you can. But probably the most thing, besides being a buyer's beware in, you know, for labeling, is now they're being spiked with other compounds. The pica, the butanaka, panaca, the MDA 2201 are all synthetic cannabinoids. So they're, again, you know, it's adding something to a product that they should not. It's kind of like recently you find heroin and cocaine. You find heroin in or fentanyl in almost everything now. You know, methamphetamine has fentanyl. So spiking these products is very, very dangerous because these products are very, very serious, and synthetic cannabinoids is a whole nother talk. But they need to be very respected. They act like marijuana, but they are maybe 100 times or 1,000 times more potent, and we need to clean the workplace of these compounds, and I can't, you know, put enough caution on that. So it is a buyer's beware. And thank you.
Well, thank you, Dr. Kuntz, for that excellent explanation about CBD oils. Let's switch gears slightly now and talk a little bit more about marijuana specifically. And even though during the pandemic, other substances of abuse have risen dramatically, and we're seeing that in the drug test positive results in workplaces across the country. For example, opioid positives have skyrocketed during the pandemic. Marijuana continues to be the really hot button issue. And so let's look at the map going into last week's general election. This is the map that shows states that have legalized marijuana either for recreational use, those are the orange states, or are for medical marijuana, and those are the blue states. So train your eyes on Arizona for a moment, okay? Just so you can kind of see how the map changed from 2 weeks ago to last week during the general election. But this is how the map looked going into the general election. And there were several states that were voting on marijuana-related issues, legalization issues. So last week, voters in Arizona, Montana, New Jersey, and South Dakota all voted in favor of legalizing recreational use of marijuana for adults 21 and older. Mississippi and South Dakota passed medical marijuana initiatives, and South Dakota actually became the first state to approve both medical and recreational marijuana at the same time. So a lot of states legalized marijuana for recreational use, and 2 more states added to the list of medical marijuana states. In addition to that, and we're going to go through all of this in detail, but in addition to that, Oregon voters voted to legalize, or really to decriminalize, the possession and use of Schedule 1 through Schedule 4 substances of abuse, controlled substances like heroin, like cocaine, like meth. It's now decriminalized in those states, and I'll explain what that means. And then in the District of Columbia, voters legalized the decriminalization of entheogenic plants and fungi. Think of it as magic mushrooms. So this is what the map looks like now. Look at Arizona. It was blue because it had already legalized medical marijuana, and it changes to orange, meaning it has also now legalized recreational use, or sometimes referred to as adult use of marijuana. And then look up at South Dakota. South Dakota was in white before, but because they legalized both recreational and medical marijuana last week through the ballot, it's now a blue state, or excuse me, an orange state, because it's got recreational marijuana. And one of the things to note about all of the orange states that you see on the map is that they all have recreational marijuana laws on the books already. And they've now, over the years, progressed to legalizing recreational use of marijuana. And if you look all the way to the far right, you see New Jersey. New Jersey was another state that had a medical marijuana law on the books already. And last week, voters voted to legalize the recreational use of marijuana. And I'm going to talk about Arizona and New Jersey specifically as I go through all of the new laws a little bit later in the presentation. But let's take a look at the key issues that relate to the legalization of marijuana generally and the laws that were passed last week. So when you're looking at a legal marijuana law, you want to look specifically for any language in the law that protects the user, or the employee in this case, the employee's rights to use marijuana and to not be discriminated against because they're a marijuana user, a legal user of marijuana, or many laws refer to being a registered medical marijuana user, card-carrying marijuana user, so to speak. And there are a lot of laws that deal with that, and I'll give you some examples. But at the same time, we also want to look for any language in a legal marijuana law that protects employers' rights, an employer's right to have a drug-free workplace program, an employer's rights to have a drug testing program, and specifically to test for marijuana, and then to take some action based on the result of that test. What you're going to see in a lot of these states is language that protects the employee and gives them the right to continue being a quote-unquote legal user of marijuana, but also protects the employer's rights to secure the safety of his workplace or her workplace by not allowing people to use marijuana while on the job, or being impaired or high on marijuana while on the job. So let me give you a couple of examples of sort of an extreme law. Nevada. In Nevada, and I'm just going to read this to you, but this is straight out of law. It is unlawful for any employer in this state to fail or refuse to hire a prospective employee because the prospective employee submitted to a screening test, a drug test, right? And the result of the screening test indicated the presence of marijuana. In other words, in Nevada, and we're starting to see a little bit of a legislative trend throughout the country that mimics Nevada. In Nevada, if a job applicant is tested and they test positive for marijuana, that cannot be the sole reason why an employer denies that individual employment. They can't do it based on the positive drug test result for marijuana. New York City, not the state of New York, but New York City took everything to the far, far extreme when they made it illegal to do pre-employment testing for marijuana. Now, there's a whole long list of exceptions for safety-sensitive positions like firefighters and police officers, et cetera. But in New York, they banned pre-employment testing for marijuana generally. And while we don't have another law exactly like that yet in the country, you can see other states perhaps gearing up, or the pro-legalization people perhaps gearing up to go in that direction. In Pennsylvania, this was just a handful of weeks ago before the general election, a court ruled that employees can sue employers for what's called medical marijuana bias. And this is following a trend that we've seen in other courts in Arizona, Connecticut, Delaware, and Rhode Island. Now, what is medical marijuana bias? Well, it's a new area of law. We'll have to see how it evolves, but essentially, it's another layer of protection for the employee or for the medical marijuana user to prevent any kind of discrimination against them. And if the individual feels like some adverse action was taken against them, they were denied employment, they were terminated employment, based on the fact that they're a medical marijuana user, they can claim medical marijuana bias. We'll see how that law evolves over the course of time. So this is a list of the states that have language that pertains to discrimination and accommodations. And if you're in any of these states, you probably have been dealing with these laws, but these are the states that so far have either passed laws or added amendments to existing laws to make it more challenging for employers to take adverse employment action against an existing employee when they test positive for marijuana, unless they can show that the individual was quote unquote impaired when they were at the time that they were tested. And we'll talk about that in a minute. So what do these accommodation clauses in these medical marijuana and recreational marijuana laws mean? Well, one, it means that a positive marijuana test on its own usually cannot be the sole reason for taking some type of adverse employment action. Because there's such an emphasis on the concept of impairment or employers proving impairment, supervisors should definitely be trained in the signs and symptoms of substance abuse, reasonable suspicion training, as we typically call it in the industry. And that workplace drug testing policies have to reflect these laws. If you're in a state that has just passed a new law, like Arizona, for example, you need to make sure that your drug testing policy aligns with the new law, with the language in the law. And this is true in any of the states, okay, that have legal marijuana laws, which is the vast majority of them now. It does not, however, mean that you as an employer cannot test for marijuana. It does not mean that you should drop marijuana from your drug test panel. And there's been no change in the impairing effects of marijuana simply because it's been legalized. In other words, the legalization of marijuana doesn't change the fact that marijuana can be a very dangerous drug for people who are perhaps performing safety-sensitive duties in the workplace. You don't want somebody high on marijuana operating a forklift or driving a big truck or anything of that nature, because the impairing impact of marijuana hasn't changed just because the law has changed. So here's some things to keep in mind. Positive workplace drug test results for marijuana reached a 16-year high in 2020. So more people are using marijuana. Remember, back in the early days of the medical marijuana legalization movement, and since then the recreational marijuana legalization movement, we were told that legalizing marijuana will not result in more people smoking marijuana. Well, we know from the federal government's annual study on this issue, as well as positive drug test results that are tracked throughout the country and among all industries, that there are more people using marijuana. More people are testing positive for marijuana. And it's going up every year. And just at least over the last 5 years, we've seen a pretty dramatic increase in the total number of people who admit to being regular users of marijuana. Permitting marijuana impairment at work is a dangerous policy to have. And by that, I mean, you've got to continue to have some kind of deterrent policy in place that sends the message to employees that they will not be allowed to be impaired or under the influence of marijuana while at work. And when you take that position, you decrease your exposure to liability as an employer. And I've got a slide coming up on that in a minute. But consider this. We know scientifically, and Dr. Kuntz is probably more of an expert, far more of an expert on this than I am, but from a scientific standpoint, as well as from a legal standpoint, the drug test result in and of itself is not proof of impairment. Somebody could use one joint and be completely impaired, and another regular user could be smoke 3 joints and not be impaired by it, or impaired by workplace standards, depending on the THC content level in that marijuana that the one person's using versus another person. The fact is that no drug test result provides full legal evidence that somebody's impaired, but it does provide evidence that somebody's violated the company policy by having marijuana in their system while they've been at work. We'll address policy issues in a second as well. Marijuana can be detected, though, accurately in urine, oral fluid, and hair. And a lot depends on the window of detection and what you want to know about that individual. Are you trying to determine somebody's lifestyle habits and behavior? Then you're probably looking at a urine test perhaps, or maybe historical use, you're looking at hair testing. If you want recent use detection, then you're most likely looking at oral fluid testing. But all three of those methods have either been endorsed by the federal government or are in the process of being endorsed. We know that urine testing has been permitted by the federal government for over 30 years. And there's a standard in place for how to conduct a urine test, both from a workplace policy perspective, as well as in the laboratory. But there's also regulations that are in development right now. Final regulations have been issued for lab-based oral fluid testing, and we're in an implementation period right now where labs are becoming certified to be able to conduct lab-based oral fluid testing under the SAMHSA guidelines. And then we know that notice of proposed rulemaking recently came out for hair testing. So urine, oral fluid, and hair are very accurate testing methods for detecting marijuana. Two areas of law that you need to be concerned about when you're thinking about whether or not you want to continue testing for marijuana or whether it makes any sense to test for marijuana. One is called negligent hiring, and the other is called Respondeat superior. Respondeat superior, basically in layman's terms, and that's the best I can do, Respondeat superior essentially holds the employer responsible for the actions of his or her employees when they're operating or functioning in the scope of their work. So if, for example, you have somebody driving a delivery van and they're doing it in the scope of their work, they're a delivery person for you, that would be considered the scope of their work. And if they're high on marijuana and they cause an accident and heaven forbid cause property damage or worse, then the employer can be held responsible for the behavior or the actions of that individual while they are representing the employer functioning within the scope of their employment. Negligent hiring is basically when an employer could have perhaps known that an individual posed a risk through some level of incompetence, but didn't necessarily make a good faith effort or reasonable investigation to uncover that incompetence. In this case, a person's perhaps drug use habit. These are areas of law that pertain to employers and their efforts to have drug-free workplaces, safe workplaces, employees who are functioning safely out in society while representing you as the employer. And it's important to know that even though laws are being passed that legalize the use of marijuana, it doesn't negate the impact or the effect of these laws on employers. You can still be held responsible for the actions of your marijuana-using employees when they're functioning in the scope of employment. And so you need to know that, and you need to be able to prove that you're doing all that you can, you're making a reasonable effort within the scope of the laws that apply to you to show that you're doing everything in your power to maintain a drug-free workforce. Now, the current consulting group conducts a number of surveys during the year, and in 2020, we conducted a survey on this issue, and we asked employers if since the start of COVID, they had discontinued testing for marijuana. And it was a very small percentage, okay? I mean, 5% was too much, but it was about 5%. But when we asked them why, a third of them said that testing for marijuana was not permitted in their state. And that's misinformation to the greatest extent, because testing for marijuana is legal in all 50 states, even though there may be some restrictions in place, like in New York City, for example, or restrictions on what an employer can do with a positive test for marijuana. There are some conditions in place in many states, but every state allows employers to test for marijuana. Testing for marijuana is not illegal anywhere in the country, with the exception of the ban that's been implemented in New York City. And keeping in mind that even in New York City, they've allowed for pre-employment testing for marijuana of individuals in designated safety-sensitive positions. So let me clarify to make sure I'm saying this correctly. It is legal to test for marijuana in all 50 states. The only jurisdiction that has banned testing for marijuana is New York City, which has only banned pre-employment testing for marijuana, and it also has a list of exceptions for safety-sensitive positions. So it's still legal to test for marijuana. Now, last week during the election, as I mentioned, a lot of states voted on legalizing marijuana for recreational medical use. And let's look at a few examples right now. So I'm gonna focus in particularly on Arizona and New Jersey, but I'll take you through each one of them quickly. So Arizona Proposition 207. You can see at the top of the screen, it passed handily with about 60% of the vote, legalizes the use of marijuana for adults 21 and older, okay? And the state's gonna set up regulations for the cultivation and the sale and the transfer of marijuana. But there was workplace language in Prop 207, okay? It specifically says that employers retain the rights to maintain drug and alcohol-free places of employment. Doesn't add a lot of detail to that, okay? But it does have that phrase in it. It also allows or does not require employers to accommodate the use of marijuana for any reason in the workplace. And it also does not restrict an employer's ability to prohibit or regulate conduct that may be permitted by Proposition 207 in or on business property. So that means that even though marijuana has now been legalized for recreational use in Arizona, an employer is not allowed to use it at your place of employment. They're not allowed to use it in a vehicle that's used for employment purposes. Probably, and this is all developing, okay, but that probably even means an individual's car if they're using that car within the scope of their employment. So Arizona is an example of a state that has legalized marijuana. It had already legalized medical marijuana, but it's legalized marijuana for recreational use by adults 21 and older that included some protections in the law for employers. Now, there's a lot more to the Arizona law than just that. But when we look on the map, right, Arizona is now an orange state, meaning it's legalized for recreational use. A lot of times, medical marijuana laws are passed, and they will include very specific language about the workplace. And some of them even refer to drug testing or drug test results. Arizona is very similar, except that you're going to find some of that language in the recreational marijuana law, which you don't find in a lot of states. So I refer you to the Arizona law to look at the details of it, because as you can see up there on the fourth bullet down, it will go into effect once all the ballots have been counted and the governor basically declares the law in effect. Mississippi passed medical marijuana, and you can see again by a fairly large percentage. In fact, in Mississippi, there were 2 ballot initiatives. Both of them passed. Both of them create a program within the state for the cultivation, the sale, and the use of marijuana for medical purposes. And it joins a long list of states and US territories that have legalized marijuana for medical use. In Montana, right, very, very conservative Montana, by a 56% vote, recreational marijuana was passed, okay? But there's a lot in the Montana law pertaining to the workplace. So under the subhead there, marijuana in the workplace, let's just go bullet by bullet. Employers are not required to permit or accommodate recreational marijuana use in the workplace or on company property. Like I explained before, that could be places away from the workplace, like a vehicle when you're representing your company and using the vehicle within the scope of employment. Employers can still discipline employees for violating the company workplace drug and alcohol policy. Make sure you have a policy in place, because if you do take any type of adverse employment action based on something related to marijuana, you're going to want to show that it's in your policy, and you're going to want to be able to show documentation that you shared that policy with your employees, that they had every possible way of knowing what the company policy says. Employers can discipline employees for working while intoxicated by marijuana. It doesn't necessarily talk about a drug test being proof of impairment or intoxication. Employers can deny employment to an applicant based on a violation of the drug and alcohol policy. Well, what does that mean? That means in your policy, you have to specifically state in your pre-employment section of the policy that a positive test for marijuana in a pre-employment test is considered a violation of the company policy. Either put that in your pre-employment testing section or put it in the consequences section of your policy, but preferably in both areas so that there can be no misunderstanding about what the intent of the policy is. And as well, employers in Montana can take adverse employment action against an employee, again, for violating the company policy. The company policy has always been key, but it's becoming more and more important than ever, especially in states that have legalized marijuana. So make sure your policy is not a one-page, one-size-fits-all, but that it has very detailed explanations of what the company policy is, especially regarding marijuana. Montana also passed, well, in addition to, I should say, it amends the state constitution to establish a minimum age for the use of recreational marijuana and for the marijuana market. This particular amendment didn't address the workplace, but it does establish that, that change in the state constitution that was needed in order to legalize recreational marijuana use. New Jersey's an interesting case, okay? Passed by a fairly significant percentage, almost 67%, legalizes recreational marijuana, sets up, or it puts into motion the setting up of a marijuana marketplace and industry within the state with sales tax and things of that nature. What's interesting is that public question number 1, which I wrote an article about a couple of weeks ago, says nothing really about the workplace, doesn't address the issue at all. But the state medical marijuana law has a lot of language in it on the workplace. And so you can see that there's probably going to be a connection made in terms of some of the anti-discrimination language toward marijuana users that's in the medical marijuana law. You could probably see how that's going to transfer over and be applied to the new recreational marijuana law. In addition to that, however, even in states that pass recreational marijuana laws or even medical marijuana laws and don't include workplace language, other states have already established legal precedents for how positive test results will be handled, what employers can and cannot do when it comes to the legal use of marijuana by their employees, by applicants who maybe failed a pre-employment test for marijuana, like we saw with Nevada, where you could literally show up high on marijuana for a job interview, and if you test positive, the employer can't deny your employment to you based on that positive result, even though you showed up to the interview high on marijuana. You might have to deny employment for some other reason, and competence would probably be a good argument. But Arizona and New Jersey are examples of states that have very aggressively gone forward with recreational marijuana and have sort of defined, in the case of Arizona, some workplace parameters, but not really. And in New Jersey, they've completely punted on the issue at this time. And so we don't really have legal precedents in New Jersey, but it's going to come. It's definitely going to be there. And we already know from the recent court ruling in Pennsylvania about the possibility of medical marijuana bias. Somebody claiming that an employer took some type of adverse employment action solely because the individual is a medical marijuana user. That's going to be sort of the definition of medical marijuana bias. South Dakota has the honor, the distinction of having passed both a medical marijuana law and a recreational marijuana law at the same time. If you go down to that second to last bullet, this is under the medical marijuana law. It prohibits the operating of motor vehicles while under the influence. There's no standard established in the law for what under the influence means, but probably what it's going to come down to is, because you can see, however, a medical marijuana user isn't considered under the influence solely because they have marijuana metabolites that appear in quote unquote insufficient quantities to cause impairment. But we don't know what that is, right? Because it's different from person to person. So in addition to maybe being pulled over for erratic driving, perhaps, the police officer is also going to have to conduct some type of roadside cognitive or impairment test as well. to add that to whatever the result of a test might be. And then this is the workplace language in the South Dakota medical marijuana law. And you can see employers are not required to permit medical marijuana use in the workplace, and they're not required to permit employees to work while under the influence of marijuana. But there's also that qualifying statement about insufficient concentrations to cause impairment. An area of law that's just this, it doesn't really exist yet, and it's in development. And we're seeing more and more states pass marijuana-related laws that refer to impairment or under the influence or some type of drug test reference like insufficient concentration to cause impairment. And it doesn't really have any legal precedence yet. So an area of law that's going to be in development is, as now the vast majority of states have legalized marijuana. And we know that in a future administration, there is probably going to be much more sympathy or empathy perhaps for the marijuana issue, and perhaps the passing of a federal law that removes marijuana from Schedule I of the Controlled Substances Act and puts it into one of the other schedules, 2, 3, or 4, where there are less restrictions on it. Possible. There was legislation that didn't go anywhere leading up to the general election. We're probably going to see something like that come back around again. And then let me just go past this real quickly to Oregon before I run out of time. I just want to talk about Oregon for a minute. So Oregon becomes the first state to decriminalize the possession and use of Schedule 1 through 4 drugs of all kinds: cocaine, heroin, meth, you name it. If all you have on your possession is just enough for, or what's considered just enough for personal use, then you're not going to be thrown into jail for that. You could be fined up to $100, not necessarily $100, but up to $100. And, or you can choose to go into some kind of treatment evaluation and go into a state-funded treatment program. The funds for that program are going to come from the sale of medical marijuana, the proceeds of the sale of medical marijuana. So the medical marijuana law in Oregon is going to be funding free access to drug treatment for people who are picked up and are found in possession of just enough heroin, let's say, or cocaine for personal use. They can either pay the fine or they can choose to have a drug evaluation done and then perhaps go into some type of drug treatment program. This is a very similar law to what we've seen in other countries, like Portugal, for example. And so in Portugal, all drugs are legalized in the sense that no one's put in jail for having a personal use possession level of heroin or cocaine or meth. And Oregon now follows that process. It's interesting to note that in Oregon, this bill, which voters approved by a margin of 55.8%, was promoted by and supported by many medical associations of doctors and nurses and other medical professionals. So it was well-funded, well-supported, and had received a lot of money from outside sources. We're going to probably see more of this coming up in the future. Remember, during the Democratic primaries, there was at least one candidate who said he was in favor of legalizing all drugs. And if you go back to the 70s, when the legalization movement really started, that was the initial objective, was to decriminalize or to legalize all types of drugs. And then, of course, at the time, there was no appetite for that. So they zeroed in on marijuana and then eventually on medical marijuana. Now we've branched out from that. In addition to Oregon, the District of Columbia voters also passed a law that would decriminalize the possession of entheogenic plants and fungi, or psilocybin, or containing psilocybin or mescaline, etc., often referred to as magic mushrooms. Now, any law that's passed in the district, I shouldn't say any law, but laws that are passed in the district are required to go through a congressional review. And so we'll see if Congress approves this or approves the will of the voters by allowing this to happen. It's not the same as Oregon. It didn't decriminalize the possession of heroin or cocaine, for example, but it did for quote unquote magic mushrooms. And so we're seeing an encroachment on these kind of sacred areas of prohibition that have existed for decades. First with marijuana, but then beyond that to these other types of drugs that have proven to be very dangerous and very addictive. we'll see what happens, right? But we're sort of venturing into a whole new era of drug use, drug abuse, and drug legalization in the United States. And with that, Thomas, I'll turn it back over to you for any questions from our audience.
Thank you so very much. A lot of great information. Again, we're going to dive straight into questions. I know we're limited on time here. First question, I think, is for you, Dr. Kuntz. Can my company test if a drug test was positive for CBD oil and not marijuana?
That's probably going to be a little bit of your policy, whether they're going to allow that. We certainly have the ability to test whether samples contain CBD or THC, and then make interpretation from that. But we have the ability to test interpretation. May be a bit confusing when we're all done.
Do medical marijuana bias claims change safety sensitive protections at all?
Ooh, who knows right now? I wish I could give you a really clear answer on that one. But these court cases these decisions, particularly the one that I was referring to in Pennsylvania, are new, but they do create another avenue for the individual, for the employee, to be able to claim, at least file a claim, that that accuses the employer of some type of bias against them simply because they were a medical marijuana user. What does that mean? Well, it could mean an employer saying, hey, I don't want any marijuana users in my workplace. And the person produces a registration card and the employer says, I don't care. I don't want any marijuana users here. Well, that could be probably considered medical marijuana bias, but it's an area of law that's really new. So the second part of your question, though, it does possibly create an impact on safety, a negative impact on safety in the workplace or employers' efforts to create safe workplaces, because I think over the course of time, it probably makes the employer a little bit gun shy, to use that phrase, to have a drug testing program in place that includes marijuana or taking action based on a marijuana positive result. And so some employers may be hesitant, let's say. And we know that some employers over the last several years, as marijuana has been legalized, have come to the false conclusion that testing for marijuana is not permitted in their state. We've got research that shows that, and that's just not true. And so there's a lot of education that needs to go on to help employers understand what their rights are. And in virtually every state that's legalized marijuana, employers still have the right to prohibit individuals from using marijuana at work and from being under the influence or impaired by marijuana while at work.
Well, and I think you said a key phrase there, right? Education. I know we constantly talk about educating your workforce and making sure that they understand that, hey, just because this law passed doesn't mean you can go home now and smoke marijuana and come back onto the job site or smoke on your lunch break. And so that education from the employer to the employee direction is going to be absolutely paramount in making sure you don't lose a good employee who that potentially just misunderstood the law and thought something was allowed now.
Yeah, absolutely. And that education effort has to be ongoing. That's in part how an employer can come back later if they're ever challenged and say, listen, I made a good faith effort. I was doing everything possible to secure the safety of my workplace. Here's the documentation that shows the training we provided, the education we provided, the drug testing that we do. And that paper trail of documentation will be the lifesaver for some companies that get challenged in the future when a legal user of marijuana tries to claim medical marijuana bias.
Gotcha. Last question. I know we're tight on time. Do you expect New Jersey to address employer protections prior to it going live in January?
No, I don't. And I based that a little bit on the research I did to write an article recently on public question number 1 in New Jersey. The conclusion I came to in the article is that at least initially, employers will probably have to fall back on the provisions that are found in the medical marijuana law and apply them to the recreational use of marijuana. But we simply don't know yet. Unfortunately, I think it's going to take some legal action before employers really have a clear idea in New Jersey what to expect.
Awesome. Hey, Bill, thank you so much. David, thank you so much. Greatly appreciate you spending a couple of minutes with us here and helping us kick off Day with DISA on such a high note.
Thank you.
You're welcome. Great to be with DISA on Day with DISA, which has become an annual event that the entire industry looks forward to. Way to go.
Well, hey, both of you have a great day. And to our attendees, thank you so much for attending. We hope to see you in some of our other sessions over the next couple days.